Goeienaand, dis die begin van 'n splinternuwe maand en die tweede helfte van 2017 het aangebreek. Baie welkom by Fokus. Ek is Lenet Francis, regstreeks uit Johannesburg. 'n Onlangse hofuitspraak word beskou as 'n groot deurbraak vir slagoffers van seksuele geweld. Die Hooggeregshof in Johannesburg het beslis dat die wet wat bepaal dat sake van seksuele mishandeling na 20 jaar verval geskraap moet word. Dit beteken dat slagoffers van seksuele misdrywe selfs na 20 jaar 'n saak kan indien teen diegene wat hulle mishandel het. Ons praat nou telefonies met Angelique Sherry-Lambus van Ian Levitt Prokureurs wat die vermeende slagoffers verteenwoordig het. And thank you so much for joining us this evening, Angelique. Just give our viewers some background to this case and the subsequent judgment, and whether you were confident in the beginning to take this case on, given the fact that no one prior to this appeal has challenged this.
Hi, Lynette. Yes, hi, nice to speak to you. The background of the story basically is that 8 victims approached Mr. Ian Levitt, my boss, who were allegedly sexually abused by Mr. Sidney Frankel, who is a stockbroker, well-known stockbroker in South Africa and Johannesburg. What happened was we first approached the NPA in order to bring forward prosecution against him. Unfortunately, the 20-year prescription regarding sexual offences still stood, and the NPA unfortunately could not prosecute him. We then decided to first approach the Constitutional Court in order to make the law unconstitutional. The Constitutional Court, however, denied us direct access to them, and we then had to approach the High Court, which was heard in May this year. And our next step now is to go to the Constitutional Court to have the law confirmed.
What were the legal concerns at that time? Because quite a number of years had lapsed prior to this initial challenge.
Yes, so the legal concern is obviously the prescription issue, in that sexual abuse after 20 years cannot be prosecuted. It's not like rape, which has no prescription. So we basically had to approach the court in order to change the law, otherwise we could not prosecute Mr. Frankel. Unfortunately, as I'm sure you know, Mr. Frankel has subsequently passed away. However, this law will change the path for future sexual assaults that have happened.
The fact that he's passed, Angelique, and that this was a civil challenge or a lawsuit, what implications does that have? Because the primary applicant then, or the challenger, is no longer there. What happens then, and how is that then resolved?
So the fact that he's no longer around doesn't actually change anything for us. We're still going to proceed to the Constitutional Court to have the law confirmed. Unfortunately, we cannot prosecute him, which was the ultimate goal for our clients, was to put him in the box and have him cross-examined and, you know, have him eventually go to jail. Unfortunately, that's no longer the option for us, but we are still proceeding to change the law and also proceeding against his estate civilly.
You made reference to prescriptions. For a lot of our viewers who aren't legally minded, who are laymen, what does that mean, and how does it refer to this particular judgment?
So in terms of South African law, sexual offences prescribes after 20 years. So after 20 years after the act has been committed, you cannot prosecute. That applies for sexual offences in the past. Hopefully now we can change that. However, that doesn't apply for crimes such as rape, murder, treason. That doesn't apply in South Africa.
And the fact that there's distinctions between when it's considered rape and when it's considered sexual offences, can you clarify that for us, please?
So that is quite a complicated question. Previously in the past, rape only included penetration. However, it has now changed, and what actually did happen to our clients is defined as rape now. However, because it was so many years ago, it wasn't defined as rape back then. So a sexual offence now would include anything that doesn't involve penetration.
Angelique, thank you so much for your time. Dit was Angelique Sherry-Lambus van Ian Levitt Prokureurs wat ons agtergrond gegee het tot hierdie hofsaak en dan ook die hofuitspraak. En om dit verder te bespreek, praat ons nou met Dr. Shaida Omar. Sy is direkteur van kliniese dienste by die Teddy Bear Kliniek, en Vincentia Dlamini, ondernemingsdirekteur by die organisasie Women and Men Against Child Abuse. So what does this judgment mean to victims and survivors?
Well, I think it's a landmark judgment. It's a major feat. It's a huge victory because it now opens the doors for victims where previously they were restricted to the statute of limitations. What one needs to understand and appreciate is that disclosure is not a single event. Disclosure is a process. For many victims, it may take a lifetime. Some victims may never disclose. But with the prescription being removed, and there was it was 20 years where the statute of limitations was 20 years, a lot of victims who became empowered or enabled to come forward were not allowed this access. They were denied the access because the prescription period had lapsed. And as a result, they were not able to proceed or enter the criminal justice system. So therefore, this opens many doors. We've had many calls. The floodgates have certainly opened, where we've had victims from rural areas calling us, sending us emails and wanting to pursue and persevere the sexual offences of the past, which they sat with and now feel that they are in a position to come forward and get closure. Besides getting any kind of criminal proceedings, it's about getting closure and being recognized. This is what this judgment means, that victims will now be given the platform to be acknowledged and recognized and validated. Because you asked something very critical to Angelique about the distinction between rape and a sexual offense, which previously, if we talk about the sexual offense, was referring to fondling, touching the genitalia, any indecent assault. So again, having worked with victims, child victims and survivors who are adults now, having gone through that traumatic experience, if one looks at the long-term implications and the trajectory that they've gone through, there isn't a distinction. A lot of the victims of sexual assault have suffered equally, if not more. So the post-traumatic stress disorder, the clinical comorbid features of depression, suicidal ideations and attempts, substance abuse, risky sexual behavior, all of that aligns itself to this.
I want to get back to that after our break, but why do you think, Vincenzo, why has this Section 18 of the Criminal Procedures Act never been challenged prior to this?
I think because we are a progressive nation, I think in terms of legislation in South Africa, and South Africa as being one of the countries with, with good legislation. And I think not only this piece of legislation still needs work on it, so it takes time. And right now we are in a position where a group came and said, this is what we wanted to do, and approach attorneys and had Teddy Bear Clinic as friends of the court and had us and rope everybody in and actually, going for this law that said that when you are sexually assaulted and you were seen as somebody who's less victimized than somebody who's been penetrated, because the courts, the criminal justice system has been seen to be a bit sympathetic to rape victims than sexual assault victims. Like Dr. Shaida has mentioned, the ramifications cannot be separated, because you can imagine a minor child who's been sexually assaulted by somebody that they trust. This is your father. You know your father to be somebody who needs to protect you. And then we had a law that said that you cannot do this. So I think we need to rejoice in the fact that currently this is a landmark victory and we need to go forward. And also because we have a community that is so judgmental and actually ask questions and say, why were you quiet all along? We need to educate the public. And when you educate the public, we explain to the public. And Dr. Shaida has mentioned that disclosure is a process. It doesn't happen that, I think the individual needs to understand that there are matters except for sexual assault.
So what we're going to do after the break, we're going to discuss disclosure. We're going to talk about silence and why people prefer to be silent, and also memory and how do you prove that and what weighs heavier. So na die breek sit ons die gesprek voort en dalk ook net byvoeg. Ons vra om verskoning indien hierdie gesprek te sensitief is vir sensitiewe kykers en luisteraars. Ons praat vanaand oor die belangrike hofuitspraak vir slagoffers van seksuele misdrywe. Die Hooggeregshof in Johannesburg het onlangs beslis dat hierdie misdrywe nie na 20 jaar moet verval nie. Ons gaste is Dr. Shaida Omar van die Teddy Bear Kliniek en Vincentia Dlamini van die organisasie Women and Men Against Child Abuse. And during your point that you made about the distinction that the court used to make between rape victims and those who suffered sexual offences, it reminded me that this conversation could be a trigger for people that have been living with this trauma for over 40, 50 years. And we suddenly talking about this, and it opens up a can of worms. How do we help victims to take this forward? Given the fact that there's memory that's going to be challenged, how do they prove after all these years that what happened to me is valid and people need to take account and be held accountable for that?
I think one thing that the victims of sexual assault need to hear is that somebody acknowledges that this has happened to them at that time, because at that time when they were minors, a lot of children cannot comprehend what happened to them. Some didn't know that this was wrong, it was wrong for them. As they grow old and they become more empowered, then they realize I was actually violated. And then when they try to speak about it, they're silenced, or somebody just tells them, you say anything, they are just, if you say anything, I will kill you. Where are you going to go? So there's a lot of factors that are contributing to the silencing of victims. I think right now, how do we assist our victims? Is that if your family, if your families and your friends do not want to listen to you, we have organization. We are here. Teddy Bear is here. Women and Men Against Child Abuse is here. We are here to help you go through this. And I know there is a question about people having to worry about, but it happened in 1982. How am I going to remember? That is not important. You know, the courts obviously don't expect you to remember the day in 1985, how it happened. So that it is going to be a challenging, journey for victims, because we also know that the defense attorneys are going to have, and the offenders are going to have delay tactics, and actually it's going to be an emotional journey for them. But we are going to be giving support to our victims, and I think, Shaida, you can just add on that as well.
Yeah, and I also wanted to ask you, Shaida, why did the Teddy Bear Clinic decide to become a friend of the court, and why was it so important to be part of this challenge?
Well, I think firstly to understand that we work with victims of child abuse, and a lot of the mothers that come to the clinic, 60% of them have themselves been victims of child sexual abuse, and they've never addressed it or resolved their issues. And so we've been facing this challenge for a long time, and we looked into our archives, went back to case studies and looked at the trajectory of these victims, and found that a lot of them had actually been negatively affected. As I had mentioned, all the risk factors earlier on, that some of the implications of not making the disclosure, not getting any kind of closure or resolving that, had resulted in some of these risky behavioral patterns. So we felt that something needed to be done, and we looked at research and worked with the Center for Applied Legal Studies to become friends of the court, to inform the court in order to enable them to make an informed decision around removing this prescription and providing relief. So that was one of the reasons. But also realizing that, as I mentioned earlier, you said to viewers out there, that certain cues, whether it's sensory, visual, auditory, can trigger repressed memory. Sometimes seeing a newspaper article or watching an explicit scene, or driving through a street and then seeing something on a billboard could trigger these kind of memories, and it suddenly comes to the fore, and then the victim is feeling quite flooded, immobilized and frozen, getting to a stage where they feel totally frozen and beginning to now process what had happened in the past. So for these reasons, having worked with survivors of abuse, we felt that this prescription needed to be worked on and to release victims so that they could move forward and, of course, encourage other victims also to come forward. So these were some of the reasons that gave impetus to this application.
There was something that I read which I didn't quite understand, the limitations to non-penetrative and or digitally penetrative offences. What does that mean? Does that also play into the differentiation between what was rape and what is just a sexual offence? Was it referring to that?
Yes, because previously, like you have mentioned, that our law only recognized that penetration by a penis, but when the new sexual offences came into place, a number of sexual offences were actually included, because like anal penetration was also included as part of rape. You know, penetration by a finger was also included in that as it being rape, to be categorized as rape. And then now sexual assault currently would mean that fondling, you know, touching your privates, you know, allowing a child to have oral sex with you. So that is what is part of what is currently saying. This is why because it's very linked, it's closely linked to each other, and the ramifications are similar.
So after the break, we'll talk about the implications in terms of memory and proving and the type of assistance that is available. Bly ingeskakel, daar is nog baie vrae. Ons is nou terug. Dr. Shaida Omar van die Teddy Bear Kliniek en Vincentia Dlamini van Women and Men Against Child Abuse is vanaand hier om te praat oor die hofuitspraak dat seksuele misdrywe voortaan nie meer na 20 jaar gaan verval nie. And if there's a lot of our viewers watching this interview and saying, I never could talk about it. I don't even know, even after this judgment, will I have the courage and feel safe enough to talk about it. Why don't people talk about it, Vincentia?
It is, there's a number of factors that come to play when you talk about why victims are not going to talk about sexual abuse. One, there's a lot of stigma attached, you know, communities and even families. And a lot of our victims, so it starts from the family. They start telling their parents. And when you go to your parent, it's somebody that you trust. If somebody that you trust doesn't believe you, how do you get the courage to speak about it? Number two, fear of what's going to happen afterwards. If I say what my father did, what if he really kills me or kills my family? How are we going to survive? Because he's the main breadwinner. And then the other thing is that children at that time don't know it's wrong, because they are actually drawn into secrecy by the ones that they trust so much. So during that time, because they are still young, it is quite very normal that children are just going to keep quiet. And sometimes even they try to speak about it, they can recant because they've realized, oh my God, what have I said? Then they just go back and say, and actually retract the statement. So it is quite normal for victims of sexual assault, even when in their adulthood, some at that time would be having, you know, they're still fearing the stigma. They don't know exactly how to go about. Some have children to consider that if I start talking about this, I have a husband now. How am I going to get the courage to deal with this? So society needs to understand that it is quite normal. This is how sexual assault, and a lot of offenders actually, you know, instill fear because they play mind games with their victims, and they want to, you know, actually victimize them even further. So they are just going to manipulate them. And we've seen in our cases, I can just quote Bob Hewitt, I can quote Sidney Frankel. They've got power, money, the status, and they will tell you nobody's going to believe you. Who's going to believe you? You're just a 13-year-old naughty girl who's a liar, and your parents trust me, and the whole world trusts me. So who's going to believe you? And you look at this child that's going to really say, but really, nobody's going to believe me. So there's a lot of fear put into, you know, actually, it's a huge burden for survivors of sexual assault.
You've touched on the aspect of fear and also this abuse of trust, of child's word against an adult's word.
Indeed, I think, and obviously, the adult misuses that position, so exploits the child, manipulates the child to say, as my learned colleague so beautifully articulated, that the child is told that nobody will believe you, it's your fault. And children are notoriously egocentric. They assume responsibility for everything that goes wrong in their lives. The child's immediate response is, I'm bad, I'm ugly, I'm dirty, unworthy of love, and children assume the typical damaged goods syndrome, and they carry that throughout their lives. And often that's one of the reasons that prevents them from coming forward and making that disclosure, because often they've been told that if you tell, I'll say, you asked for it, you're a slut, you're a whore, it's your fault, or you'll be removed. In the case of incest, as Vincenza so beautifully said, that the child will be told that mommy will be cross with you, everybody's going to blame you, there won't be food for money, there won't be food or money for school, and those are some of the reasons we find that people don't come forward, children don't come forward, even as adults, it's still a social stigma. Who is going to believe me, and why, after so many years, am I now coming forward and making this disclosure? But as Vincenza said, that organizations like us, we are there to validate and support and back victims, because we realize what motivates a victim or an individual to come forward after so many years. And of course, the onus of the burden of proof will depend on organizations like ourselves to conduct assessments and support these victims through this process, and to use the criminal justice system to give them equal opportunity and access to getting some kind of closure.
So within a minute, what happens now? Because there needs to be some changes. Vincenza?
Okay, what happens now is that within 18 months, the High Court has actually given Parliament to amend the law, and then we can start with cases, you know, and we go on and we allow victims to have a law that says, yes, you cannot be unsexually assaulted, and we recognize that it has lifelong effects. So this is where we are going. So sexual assault, Section 18 of the Criminal Procedural Act is unconstitutional, as it has been said in the judgment. So we are going with the law now, which allows everyone to have, you know, recourse for what has happened to them.
So if there are some of our viewers that feel courageous enough to take this and say, I'm going to let myself be heard, what is their next step?
Well, they need to contact places like the Teddy Bear Clinic, Womaka, and
do they have to go to a police station?
Firstly, you are absolutely correct. It needs to be reported. A criminal case will have to be opened, and then due processes will have to be followed. Assessments may have to be conducted, but they need to also get support. And I want to just end that there are many Sydney Frankels, so let's not be fooled. We need to be aware that it's the likes of you and me that abuse children.
Well, we're going to have to leave it at that. Thank you so much, ladies, for coming in this evening. Net voordat ons groet, ons innige medelee aan die families, die vriende en kollegas van twee van ons SAIK-kollegas wat die afgelope week oorlede is. Suna Venter van Monitor Spectrum en Zama Mbalo, wat dikwels ook vir Fokus skitterende kamerawerk gedoen het. Ons is volgende Sondag aand om 6uur weer hier op ons pos op SABC2. Laat weet ons wat jy dink, stuur gerus jou kommentaar, jou tweets en voorstelle. Besoek ons Fokusblad op Facebook, soek onder by Fokus SABC, volg ons ook op Twitter by Fokus ZA. Sê baie dankie aan al ons gaste vanaand. Tot volgende Sondag aand om 6uur. Hoop dit is 'n goeie week. Mooi bly.